All right. Mr. Franz, you're up.
Good morning. May it please the court, Kevin Franz on behalf of Owners Insurance Company. I'd like to reserve 5 minutes for rebuttal.
Sure.
The trial court erred in finding the $25,000 CRN cure payment was a confession of judgment. A timely CRN cure is not a confession of judgment in a traditional action where coverage is not denied. In this case, owners cured the CRN to settle and avoid any extra contractual damages. The claim was rendered moot by paying the policy limits, and the trial court should have dismissed this case with prejudice.
Mr. Franz, can I just interrupt right now? Because I think what we're dealing with at the beginning, when this case was first, tried, not even tried, and developed, when the court heard this matter, it seemed to be an issue of first impression. And it appears now we have a Castro case that the First District Court has ruled on. So I think the question, for at least for me, let's address Castro in this case. Is Castro?
Your Honor, I think you were just muted. I'm sorry.
We've lost you verbally, Judge Kazan. Uh-oh. All right, I think we probably need to pause. I'm going to pause your clock, Mr. Franz, and we will see what's going on. It's amazing. We don't usually have too much technical trouble, but we have some.
IT is trying to contact her right now to figure out what the issue is, Judge.
Great. Thanks, Ted.
You're welcome.
And Mr. Franz, you were paused at 1 minute into your argument. So
Thank you, Your Honor.
I could hear you. Oh, okay.
we can hear you now, Judge Kazan.
Oh, wonderful, wonderful. Let me get back. I was talking to Rita. Can you hear me now?
Yes.
Oh,
Here
wonderful. Okay.
All right. We'll start us back.
Okay.
Start us back up. All right.
Okay, thank you. So, Mr. Franzo, I guess my question to you is Castro on point in this case? And if it's not, why is it distinguishable from the facts of this case?
Well, factually, it is distinguishable. I do believe Castro was wrongly decided, but I'll explain why it's factually distinguishable. In Castro, the opinion indicated that the plaintiff there demanded payment pre-suit, and the failure to pay pre-suit forced the plaintiff to file suit. And it was based on that forcing them to file suit that the confession of judgment doctrine applied, because the confession of judgment doctrine does not apply unless the insurance company wrongfully denies coverage or forces someone to file suit. And in Castro, in here, there is no allegation that there was any pre-suit demand. In fact, the initial CRN, and during the argument in the trial court, counsel for Owners Insurance said there was a CRN, but there was no demand for anything.
Well, let me ask you this, Mr. Franz. The fact that there was a CRN before filing suit, why isn't that? Can it be argued that that's almost like a request or a demand for your client to pay them prior to, since there was a CRN done before suit was filed?
Well, the CRN needs to explain what the plaintiff wants to occur. In this case, the CRN is not even in the record in this case, the initial CRN. So there's nothing in the record to show there was any pre-suit demand, and plaintiff's counsel did not refute the fact that there was no pre-suit demand. So that factually distinguishes this case from Castro. And honestly, if this court follows Castro, it would have to find that there was no forcing of a lawsuit in this case. And because there was no forcing of a lawsuit, the confession of judgment doctrine does not apply. But Castro was wrongfully decided. And really the big issue that the Castro court has, and what it got wrong, and what the plaintiff gets wrong in this case, is that they don't recognize the significant difference between a UM suit, a traditional UM suit where there's simply a dispute as to the amounts owed, versus a UM suit where the plaintiff seeks damages under 627-428 because there was a denial of coverage. And the case that really explains this well is the State Farm versus Peterson case out of the 4th DCA. In that case was a traditional UM action where the insurance company admitted coverage, but disputed the amount owed. And that can come for any variety of reasons. Bodily injury, the tortfeasor's bodily injury payments may have been already paid to the insured. The insured may already have PIP payments. So before you even get to uninsured motorist coverage, the plaintiff has to recover a certain amount higher than over the bodily injury limits, over the PIP payments, and sometimes there's causation issues. So that's what I mean by there's a dispute as to what is actually owed. So that's what happened in the Peterson case. The plaintiff served a CRN in that case or filed a CRN, and the insurance company timely cured it by paying the policy limits. The plaintiff said, aha, you owe us attorney's fees because you paid exactly what we were looking for. So under Wallard, you have to give us attorney's fees. And the trial court agreed. But the appellate court reversed and said, no, there was never a denial of coverage. The suit did not seek fees, and it could not seek fees under 627-428. Therefore, there's no confession of judgment here. Wallard does not apply. We have the exact same factual scenario here. We admitted coverage. The plaintiff was not forced to sue because—
Okay, and help me out, Mr. Franz. When did you admit coverage in this record?
There, from our answer to affirmative defenses, we did not deny that there was coverage.
Okay, but you said something differently. You said in this case you admitted coverage. So where in the record is there? Help me out. Where in the record is there where owner said we absolutely have coverage, we just dispute the amount that you're claiming?
It would be certainly in the answer and affirmative defenses. Because there's no denial of coverage, and in our motion for entry of judgment, we admit that there is coverage, and the plaintiff agrees that we admitted coverage. The plaintiff does not dispute that in this case. I believe even in their answer brief, they agree that we admitted coverage. So there's no fact dispute about that. And so therefore, this case was a traditional UM action where we did not force the insurance company, the insured to file suit. And again, under the Clifton case from the 2nd DCA, Clifton versus United Casualty Insurance Company from 2020, the confession of judgment rule only operates to penalize an insurance company for wrongfully causing its insured to resort to litigation. And the courts have interpreted what wrongfully causing an insured to resort to litigation means, and that means a denial of coverage. And again,
so it's a denial of coverage as opposed to, and let me circle back to the pre-suit CRN, because that kind of, the fact that there was a pre-suit CRN, and then I know you've indicated that owners basically went back and say, provide us with any information. Is there an ongoing obligation from owners to pursue that? It's like, okay, you filed this CRN, let's find out more about this claim. And so what's the time period? And the main reason, I know we don't have it in the record, however, it was mentioned in the record that the attorney mentioned it to the court that there was a CRN filed pre-suit. So, you know, it appears that that has been done, and there's no dispute that the CRN was done pre-suit. So the question, I guess, for me to ask you, Mr. Franz, is that what obligation does owners have? Do they simply say, give us whatever amount and then just sit back and wait? Or do they pursue and say, let's investigate this cause more to see whether or not they need to, you know, provide the $25,000 in coverage?
Owners has an obligation to, you know, engage in good faith claims handling, absolutely under the law. Again, as Your Honor recognized, the record does not have any real information on this, but what it does have is that there was a CRN. We don't know what it said, but what we do know is that owners, when it received this, said something to the effect of, there's no demand made in the CRN. Please provide us information to help us evaluate the case because we needed to get medical records and the like. That's the only record evidence that we have in this case. In the Castro case, what's different here is that in the complaint in Castro, there was an allegation that there was a demand that was never a demand by plaintiff to Allstate in that case, and Allstate did not pay benefits. In the complaint in this case, that is absent. So based on the record here, there was no demand, and that is a critical distinction. What Castro and the plaintiff do is they misconstrue the narrow application of the Wohler case, which specifically only applies to 627-428. And that's based on policy reason. That subsection is designed to discourage insurers from contesting valid claims, and it applies when insurers deny coverage, forcing to file a suit. Every single insurance-related case after Wohler dealt with 627-428 or a statute that was implemented that as a fee shifting provision. We do not have that here. And the other thing that is critical to the context here is the fact that we cured a CRN. The purpose of a CRN under Lane versus Westfield is to give the insurance company one last chance to settle a claim, to avoid a bad faith claim, and to avoid imposition of extra contractual damages. The Supreme Court case in Tallet says it's to assist in settling lawsuits or settling claims. Tallet says the payment of the policy limits is the cure, and we paid the policy limits. The cure, according to Tallet, bars extra contractual damages, which includes attorney's fees. And essentially the purpose of the CRN is to settle claims and to avoid the insurance company from having to pay anything more than what its policy limits are. Otherwise, insurance companies would never, ever cure CRNs if they could still have more and more extra contractual damages imposed on them. There'd be no incentive to do that. Paying the CRN.
Well, that's true, but doesn't the CRN also save them from an action of bad faith, right? So the fact that to try to alleviate their from being exposed to a bad faith claim, that would give the incentive for the insurance company to pay off, you know, when you have a CRN. But let me ask you this, Mr. Franz. In this case, how many CRNs? Were there like 3 CRNs prepared by the appellee in this case? There's one pre-suit, and I think in the record, there was another one that somehow was mentioned in February 21. And then the third one, as I'm able to gather, the one that was ultimately agreed to be the operative CRN, that was in June 17th. Am I reading that correctly? That there were 3?
That's correct. That, at least that's from what we can tell from the record, which admittedly does not have any of these CRNs, and it was based on commentary, I believe, either in the motion or by counsel during the argument, is that there were 3 CRNs. The only one that we know of that is operative is the one that says said, please review my claim and pay policy limits. And that's exactly what we did to cure the CRN. We reviewed the claim and we paid policy limits. So there's really no dispute that we cured the CRN. By curing the CRN, that rendered this action moot. Mallet could not recover any damages greater than the policy limits in this action, which was $25,000. That payment, which was essentially a settlement, extinguished any justiciable controversy in this case, and the trial court erred in failing to dismiss the action. We don't get to the issue of the offer of judgment statute if there was no confession of judgment. If there's no confession. And
if I may, Mr. So how does, I want to have your thoughts before you get into your time for rebuttal. I know that the owners rejected a proposal for settlement that Mallet filed in the amount of $19,999. How does that play out in the argument that you're making?
Sure. Well, there's various reasons. You're wondering why would we reject that, but then accept the CRN? Is that
Yeah, I mean, it just
Okay.
seems, and we're talking about relatively within the amount. We're not talking about like $10, you know, what is it, $100,000 rejection, and then we're talking about something within the same thing.
Absolutely. So at the time that that PFS was served, we don't have to pay any damages unless the plaintiff recovers over a certain amount. And in this case, the plaintiff received $50,000 from the bodily injury insurer. The plaintiff also received $10,000 in PIP. does not kick in until plaintiff gets above that 60,000 threshold. Additionally, as trial counsel said, there were issues of causation. So at the time that that PFS was served, we did not believe the case was valued. There was a dispute in the value of the case. The CRN is a different subject altogether because the purpose of the CRN is for the insurance company, in essence, to make a business decision. Do we want to resolve this case? Or if we reject it, then we're subjecting ourselves to bad faith damages. And by the time the CRN rolled around, we had uncovered a lot more medical records than were provided initially. So there was a lot more that went into this decision to cure the CRN. And ultimately, insurance companies always have to continually engage in good faith claims handling. It was the opinion, and it's not really fleshed out in the record, but the purpose of curing a CRN is to say, okay, enough is enough. We agree to pay the policy limits from a business decision. We do not want to be subjected to any extra contractual damages. So there's the timing is different from the PFS and the CRN. The considerations are different from accepting one or the other.
Hey,
Your
Mr.
Honor,
Prince, you are at your rebuttal time.
we would respectfully request this court reverse and remand for dismissal. Thank you.
Thanks. Okay, Mr. Howard.
Thank you, Your Honor, and good morning. May it please this court, my name is Bailey Howard, and I represent the appellee, Jill Mallett. And I believe, Judge Northcutt, as far as I know, you pronounced it correctly as well. This court...
No, I can never tell.
Also, Your Honors, this court should affirm the trial court's ruling that it was obligated to enter a judgment for Ms. Mallett because owners, when it paid Ms. Mallett every cent of the damages she sought during litigation over whether it was required to pay her those damages, having previously denied that it was required to pay her even a single cent of those damages, by making that payment, it confessed judgment. And the result of a confession of judgment is a judgment in the non-confessing party's favor. And it doesn't matter whether it's in an uninsured motorist claim, it doesn't matter whether there's been a CRN served, and it doesn't matter whether it's outside the insurance context. The point is that when a party confesses judgment by paying the plaintiff's damages in mid-litigation, having previously denied that it must pay them, that is a confession of judgment, and a judgment must be entered thereon. And Your Honors, I'll jump straight in with a response to Judge Kuzam's question about the applicability of Castro. And I'll qualify this by saying that, of course, Castro is not binding on this court. I would hope this court finds it persuasive. The facts are indeed very, very similar, but it is not a binding precedent that this court must follow. To begin with, I'll address my friend Mr. Franz's supposed distinctions between Castro in this case. The first of those being that owners has never contended here that it did not deny Ms. Ms. Mallett's claim. Owners' position throughout this litigation has been that Ms. Mallett is not entitled to recover based on this, that she was not entitled to recover any of these insurance benefits, not that she didn't abide by the terms of the policy, not that she didn't exhaust the policy terms and the so to speak, administrative remedies before filing a claim. And again, we don't have the CRNs themselves in the record, but the fact that a CRN was filed pre-suit indicates that Ms. Mallett did file a claim for these benefits. You can't file a CRN for bad faith claim handling unless you have a claim to handle in bad faith. So I would say the record does support the idea, not just based on the fact that owners' position throughout the litigation has been that Ms. Mallett's claim was denied and should have been denied, but also the fact that there is a CRN addressing the handling of a claim before the case was even filed.
And Mr. Howard, let me ask you this, because Mr. Franz indicated that once that CRN was done pre-suit, and then owners responded by saying, provide us with more information. And according to them, there was radio silence from the other side. How do you respond to that?
Well, Your Honor, I can't say one way or the other anything more than the record says to substantiate that. I do think that if we're talking about the merits of a bad faith claim, whether that would have been bad faith claim handling, then under the current state of the law, that it might not have been, that might not have been bad faith claim handling at that point. I'm not an expert on those intricacies, but I think that question is ultimately outside the merits of the case here, because it is really more about, did owners handle the claim in bad faith? Not.
So the question for, because if Castro is, if we find it persuasive, Castro seems to imply that that there has to be, as I understand it, pre-suit. It's like there would be a demand for pre-suit before you file suit, that there's some exchange or some denial, which then causes the insured that have no resort but to file suit. And then later on, if the result is really paid, then that will be confession of judgment. Is that the way that you read Castro, that there's that limitation, that if you don't have that pre-suit, then you're basically out of luck later on if the insurance company ends up paying the policy limits?
Your Honor, I do read Castro that way. Castro does say that you have to have a denial of the claim. And as the Supreme Court of Florida made clear, I believe, in Johnson versus Omega Insurance Company, I may have the wrong case there, but I'm pretty sure I don't. That denial just has to be wrongful. And that was disapproving this court's decision in Clifton that required bad faith to show that pre-suit denial. But I'll qualify that answer by saying that that's the one part of Castro that Ms. Mallett disagrees with, because the requirement for that pre-suit demand grows out of the requirements of section 627.428, which is just an attorney's fee statute. It regulates what happens once you have a judgment, but it doesn't say how you get that judgment. And there's a tension in the case law here, or there's a certain tendency towards terminological inexactitude. Some cases refer to the confession of judgment doctrine as fees under section 627.428, and that's a little imprecise. The confession of judgment mechanism is when a party pays a plaintiff's damages and confesses judgment. And then you have different paths to attorney's fees from there, but the point of the confession of judgment mechanism, which is what's at issue here, is that you get a judgment. The Florida courts have used the phrase confession of judgment doctrine to refer to entitlement to fees specifically under section 627.428. And in particular, if one reads, and I apologize for having to refer to my notes as I do this, it is in fact Johnson versus Omega Insurance Company that forced to sue language, that the wrongful denial has to force the plaintiff to sue. That comes from the concerns under section 627.428 about a race to the courthouse, and the fact that a plaintiff might, as the plaintiff in Lorenzo did. One reason that State Farm versus Lorenzo is distinguishable here is that the plaintiffs in that case, they almost actively concealed from their insurance company that there was a dispute at all. And then the first the insurance company learned of the dispute was when the plaintiff served the complaint on them. And then the plaintiffs tried to use that when the insurer paid the claim. The plaintiffs tried to use that to get attorney's fees under section 627.428. And that kind of sort of gamesmanship and race to the courthouse is not something that's desirable. That requirement for being forced to sue is a reasonable, and I would even submit a wise way to prevent that. But that concern doesn't arise in this context, or indeed in any context outside of section 627.428. Because here, in order to be entitled to fees, not only did Ms. Mallett have to file a legal claim to receive those benefits after owners denied her insurance claim, but then, because she's not subject to section 627.428, she had to get to a stage in the litigation where she could serve a proposal for settlement, and owners had to reject that proposal for settlement. So there's no race to the courthouse concern that motivates the 627.428 confession of judgment doctrine's requirement that a party be forced to sue. That issue, while it's certainly live in the 627.428 context, which has now been repealed anyway, it's not a live concern here.
So,
And-
so your position is that we are operating purely under 768.79, which applies to any civil action for damages.
On the attorney's fee front, Your Honor, yes. But not that that's the only basis for a confession of judgment here. Here, confession of judgment comes from the common law and the confession of judgment mechanism. And Castro recites a lengthy history of the confession of judgment mechanism and the ways it's been used in the past. A Florida case that Ms. Mallett points to is Carroll versus Gore. It's a 1932 Supreme Court of Florida case discussing confessions of judgment. And it states specifically that it's a mechanism that comes from the common law. And so the question that's before this court in this case is whether Ms. Mallett should have had a judgment entered on her behalf. And in order for this common law rule that when you pay, or in the insurance context, when an insurer pays the insured's damages in mid-litigation over whether it must pay them, this is a functional equivalent of a confession of judgment or verdict in favor of the insured. In order to displace that common law rule, we have to have a statute that says something about it. And owner's argument purports to be a statutory interpretation argument saying that there are statutes displacing this common law rule. But Your Honors, none of the statutes that owners invoke say anything whatsoever about it. In fact, the only statute that Ms. Mallett is aware of that mentions confessions of judgment at all in the Florida statutes is section 55.05, which voids powers of attorney to confess judgment by default if those powers of attorney are made before the suit in which the default is entered was filed. And that has absolutely no bearing on this case. Section 624.155 is silent about it. Section 627.727, the UM statute, is also silent about it. And section 627.428 isn't even relevant here, but it's also silent about it. And so there's just no statutory support at all for owner's argument that the common law confession of judgment mechanism is displaced in this case. And that's essentially the basis for the ruling in Castro versus Allstate as well, that this common law mechanism applies. And so, Your Honors, I will also address another case that my friend brought up is State Farm versus Peterson. And what that case actually holds is something a little bit more nuanced than what my friend indicated that it held. That case holds that a UM claimant cannot recover fees under the UM statute, section 627.727, subsection 10, after the insurer cures a CRN, because section 627.727, subsection 10, is a path to recovering attorney's fees as damages in a subsequent bad faith claim, not as sanctions under section 768.79, as we have here in this case. And it's that distinction between damages, extra contractual damages, and attorney's fees as sanctions that ultimately becomes important if this court determines that it should reach the question of whether Ms. Mallett can get attorney's fees here. And so if this court chooses to, if this court determines rather that it's appropriate to reach that question, then this court should hold that section 768.79, because it's a sanction, is not awarding fees as extra contractual damages any more than section 57.105 would be awarding fees as extra contractual damages. The point here is almost too obvious to be worth stating. The fact that Ms. Mallett is seeking to recover these fees in her uninsured motorist action and not in her subsequent bad faith action, which is now barred because of the CRN cure, seems to Ms. Mallett anyway to answer the question of whether these are barred by the CRN cure. They're not being recovered as damages in that subsequent action. They're being recovered as sanctions here. And under the binding precedents from the Supreme Court of Florida, Ms. Mallett would have a mandatory right to fees if she's satisfied the requirements of her proposal for settlement and of section 768.79. And because the trial court was bound to enter a judgment in Ms. Mallett's favor, the requirement that she obtain a judgment in an amount that beats the PFS would then be satisfied. And so if this court affirms, that's the next direction this litigation would go. my friend also brought up the fact, or his contention rather, that Woolard is restricted to the domain of section 627.428. And that is a misreading, not just of Woolard, but of the entire line of confession of judgment cases. Now, it's true, and as Castro explains, a lot of those cases have dealt with section 627.428 because it was an insurance-specific fee statute, and it was available in most of these insurance cases. But even in Woolard, the court really is careful to distinguish between the question of whether a party confessed judgment and then whether that judgment obtained through the confession of judgment entitles the receiving party to fees under some other statute. And in Woolard, in fact, there wasn't even a judgment entered. Woolard seems to indicate that when a confession of judgment happens, that it's not necessary to enter a judgment. And that is that's inconsistent with some other aspects of case law and with the historical operation of the confession of judgment mechanism. It's Ms. Mount's position that the trial court was required to enter a judgment on her behalf. So the entry of that judgment, however, is a separate question, of course, from entitlement to fees under one of any variety of statutes. And the entitlement to fees under section 627.428 is, of course, not at issue here. But again, not to belabor the point, the confession of judgment mechanism comes from the common law and is not subsumed into, is not displaced by section 627.428.
In fact, the authorities in this case that interpret, I guess, the adoption of the common law in Florida, they say that statutes can displace common law only where they explicitly do so. That you can't do that by inference or some interpretive mechanism, correct?
Yes, Your Honor. Although there are some cases, I don't believe that the parties cited them in their briefs here, but just in the fullness of candor to the court. That
We always appreciate the fullness of candor.
Thank you, Your Honor. Well, there are some cases that I believe, I have a tiny silver bell ringing in my memory.
Right.
There are cases that say that statutes that are just so antithetical to the common law that the two can't coexist can also displace it.
I get that. Yeah.
Oh, thank you, Your Honor. But those circumstances aren't present here. There's not even any overlap between 627.428 and confessions of judgment. As I explained earlier, 627.428 only cares about what happens after you get a judgment. And so in order for any displacement to happen, it would have to be in the UM statute 627.727 or the CRN statute 624.155. And neither of them has anything to say about the subject. And Your Honors, unless this court has any further questions or use for me, I'll yield the remainder of my time to the court.
Thank you, Mr. Howard.
Thank you, Your Honors.
Mr. Franz. I think you're muted, Mr. Franz. I do that at least once a session.
I'm usually better with that. Mallet looks at this case far too broadly. Mallet is saying, well, it's a mid-litigation payment, so that's a confession of judgment. It has to be construed more narrowly. What Mallet does not really take into consideration sufficiently is Woolard applying the absurdity doctrine under 627.428. Woolard court looked specifically to the policy of 627.428, which, and this comes from State Farm versus Lorenzo, 50 CA 2007. The confession of judgment turns on the policy under 627.428 of discouraging insurers from contesting valid claims. We do not have that concern here. In fact, on page 38 of the answer brief, the plaintiff says, quote, because owners did not dispute coverage, section 627.428 does not apply here. Woolard specifically used the absurdity doctrine to that statute. Every single case other than Castro used the Woolard line of theory under that specific statute, which admittedly does not apply here. The other reason that they give this issue way too broad of a reading, that any mid-litigation payment is a confession of judgment, is because of the CRN cure, which they did not really address. Again, the CRN cure is to give the insurance company one last chance to settle a claim for the policy limits. And that's what occurred here. There is a significant misunderstanding or misrepresentation as to what a denial of claim means. We keep talking about, well, was there a denial of a claim beforehand with the initial CRN? A denial of claim under law is when you deny coverage. That comes from a line of cases, Moore versus Allstate, Florida Supreme Court, 1990. An insured can only get attorney's fees under 627-428 in a action when the insured denies or disputes coverage. The Smothers case that we cited, quote, dispute as to the amount to be paid is not a denial of coverage. There is no dispute that there was not a denial of coverage in this case. The issue that this court should examine is not whether any mid-litigation payment equals a confession of judgment. It is a timely cure of a CRN by an insurer, a confession of judgment in a action where the insurer did not deny coverage. And I think it's also important for this court to look at the beginnings of what a confession of judgment is. It generally applies in cases involving promissory notes or cases involving liquidated damages. Plaintiff says, you owe me $13,023.13. And the defendant says, I agree, I owe you exactly that amount in a promissory note. Cases are cases involving unliquidated damages. And again, the only insurance context that this has ever applied in before Castro, which we argue is wrong, was the specific narrow concept of a denial of coverage under 627-428. Accordingly, we think Castro is incorrectly decided. The trial judge in this case, the rationale the trial judge gave in this case, looking to subsect 624.155 subsection 8, that didn't preempt any other statute or remedy, which is why the judge allowed this, is completely wrong. And I don't think plaintiff would disagree, because that statute only allows for a statutory bad faith claim and a third party common law claim. It doesn't expand any further than that. And that comes from the Florida Supreme Court decision in McCullough. So the trial court made the wrong decision for the wrong reasons. Accordingly, we would ask this court reverse and remand for dismissal with prejudice.
Okay, thank you, Mr. Bruns. Thank you both very much. And
Thank you.
in order to leave our virtual courtroom, you need to click the button that says leave on your Zoom screen.
Thank you.
Head off into the ether. Take care.